Good morning, everyone. Thank you for being present and participating in our workshop this morning on our telecommunications, not telecommunications, transportation, I apologize, regulations contained in the 103-100 and 103-200 series of Chapter 103 of the South Carolina Code of Regulations. We are going to proceed with our agenda. Mr. Turaney, are you ready to begin with your summary of your comments?
Yes, ma'am, I am.
All right, good morning. You may proceed.
Good morning. Good morning. I was afraid I was going to be a little bit like the Don Quixote this morning, but I see that I'm joined by the Dean of the Transportation Bar, David Popowski. And it's always nice to see him and our friends at ORS. I guess first of all, we have a little echo. Can y'all hear me okay?
We can hear you. Let me ask the live stream team. Or how does he sound, everyone? Feedback? Yeah, you have some feedback, Mr. Turaney.
I'm not sure. This happened once before, infamously, in a transportation case at that. We'll just soldier through. I'm not sure what to do about it.
Yeah, hopefully, I think we'll be okay. I gotta check with the court reporter, make sure that she's fine. So yes, sir. Please move forward.
Well, at the outset, I just want to explain why I'm here. As you know, Ms. Boyd, I represent a lot of, or many, transportation applicants or household good movers. And there was a time when I wouldn't have thought I'd be doing that, but I've got to tell you, it's one of my favorite things to do at the Public Service Commission. There was a time, you probably know, that I wouldn't have said that. But it turned out that way, and it's funny how it turned out that way, because what I enjoy the most about representing these people is they're mostly small business people. They're entrepreneurs. They come from all walks of life. I mean, kids that are almost out of high school, that recently graduated from high school, to folks and middle-aged folks, people with broad experience. They work with their hands. They're unlike most of the people we deal with at the commission. And I get a lot of satisfaction out of dealing with them. At the same time, I think there are things we can do to preserve the integrity of the moving application process, to make sure the commission meets its goals, which I understand it takes very seriously, and I do too, of having qualified applicants that are charged with moving people's goods, people's possessions. It's a responsibility. It needs to be impressed upon them, and we need to make sure the right people are doing it. At the same time, I don't think we need to unnecessarily burden them. And I think there are things we can do to relieve that burden. As I said, these are small folks, and I know I'm taking a little bit of time with this introduction, but I think the context is important. When we layer things onto this process that aren't necessary, we increase the expense for them, and it can be significant. So I would start with my recommendations, and I made 10 of them, and I'm going to withdraw one. The ORS will be happy to hear, but I'll just walk through them. Regarding applications, and this isn't in the regulation, but we have 2 pages that require notary signatures. I don't know why we do, honestly. These folks are going to come to the hearing. They're going to raise their hand. They're going to swear under oath to the information contained in the application. I'm unaware of any other document we file at the Public Service Commission with a notary signature. So I would recommend taking those out. And that just streamlines the process. You can email the application form to your client. he can fill it out, return it to you, and you can file it on DMS. Now the guy's got to go hunt a notary and, you know, maybe come by the office. It's just, I don't think it's necessary. My second recommendation deals with orders. And as you know, this has been a bit of an issue for me and for my clients in that we have a process where we submit orders, draft orders to the commission, and the commission, rightfully so, has a review process, but you've got a client that cannot do business until that order is issued. And we typically add a month at least to the period during which this client, who by then has been approved in a vote by the commission, is waiting on a signed order so he can actually go out and earn money and make payments on that insurance policy he had to buy and make payments on that truck he had to buy. And he's really waiting on, I don't want to call it a formality, but in his eyes it is. The commission stated when I raised this issue earlier this year, and I proposed that you just allow these folks to go ahead and do business once they've submitted their insurance after the vote. The commission said no, they weren't comfortable with that, but we needed a solution to this issue. And
Yes,
I think a form order is a solution.
Yes, sir. Hold on, Mr. Training. Hold on 1 minute for me, please. Okay. Mr. Popowski,
Yes, ma'am.
would you please mute your microphone? All right. Thank you so much. I apologize, Mr. Training.
Maybe that was the feedback. I don't know, but I think a form order would be a solution. I mean, it could have a space in it for other or comments or something. If the commission felt that something needed to be added to a particular mover's order, it could be done. But I believe there are similar order, and I haven't had time to track it down, but I seem to recall similar orders in family court. I think that would be an efficient way to do it. If you had a form order, it could essentially be issued when the commission takes a vote on an application. And that honestly is something that the commission, I wish, would consider extending to other issues. I find myself in a little bit of a conundrum these days in that sometimes with procedural matters, the commission issues a detailed order and maybe a couple of weeks later, and other times it will just adopt the directive. And I think it would help all the practitioners before the commission if we had some notion of when it's helpful for us to submit an order to the proposed order to the commission, when it's necessary and when it's not. But coming back to the household goods movers, this is a serious burden that I would like to relieve on my clients. My next recommendation deals with notices by publication. And I propose that the commission amend the regulation to no longer require publication in a newspaper of general circulation. These notices have become really expensive. I quoted fees between $177 and $397 for a published notice. I've done my best to shop around, and these days the Post and Courier seems to be the cheapest newspaper you can find for a published notice. But honestly, in the days of the internet, if somebody is interested in monitoring who applies for a Class E application, they don't need to do anything more than get on the commission's website, subscribe to its daily activity report, and see what's filed. I don't think anyone is really reading these notices that we're requiring these poor people to pay for. And they're not required in the statute, as I point out. And so I would propose that the commission simply do away with them. My next recommendation deals with shipper witnesses. shipper witnesses, I, I really don't think we need them. I don't think we needed them when they appeared in person. I don't think we need them by affidavit, although I do commend the commission for allowing us to present these witnesses by affidavit. But honestly, they're a vestige of an anti-competitive regulatory scheme that is of doubtful constitutionality. The only reason for a shipper witness is that's articulated is to show that the market somehow needs another household goods mover. I submit to you, the market always needs a household goods mover who's qualified. I mean, we're not talking about a heart surgery center here. We're talking about moving people's chests and drawers. I, I, I wish I could show up at the Supreme Court swearing-in ceremony and say, hey, I like these young folks. They seem very nice and they're qualified and they got good grades, but we don't need any more lawyers. The competition is just too high. I, I, I don't think it's constitutional. I think the Supreme Court, the United States Supreme Court, has said as much, and I believe the South Carolina Supreme Court said as much, at least by analogy, in the retail services case, in which it struck down a limit on the number of liquor stores you could have in South Carolina, because it said the only articulated basis for this is to restrain competition and restrain economic necessity. I don't know of any other rationale for the shipper witness affidavit than that when it comes to household goods movers. We're not requiring this affidavit to say these are good people, and we don't do it for anyone else. Let's think about this. When somebody applies to be a telecom carrier, do we ask them to bring forward somebody who says, I want to use the phone and I need another carrier? The commission presumes this across the board everywhere else. Why are we putting people through this bizarre exercise of going to get a realtor to say, I need somebody to recommend a household goods mover? It's there. It's just kind of been there because it's always been there. It's a relic of the days when the big lines used to show up at a household good hearing and say, we don't need any more because we don't need any more competition. Well, we quit doing that. I don't remember a case like that. I don't think it's been one in 15 years. And I don't see why we need to invite that sort of problem in the future. So I would recommend the commission amend its regulations in the manner that I suggested, to delete the shipper witness requirement and to adopt a presumption of necessity that if in some way can be rebutted constitutionally, then it could be done. But that would prevent the commission from being susceptible to an as applied challenge under the due process and equal protection clause. My recommendation number 5 involved hearing examiners waiving hearings. And I recognize that may be somewhat controversial, or and it's something the commission has hesitated to do in the past. But I think it's something to think about, at least. I don't mind doing these hearings, as I said. I mean, it's a good exercise for me, and but we should consider the fact that the commission's hearing load is growing. You have a lot of things going on, such as the Energy Freedom Act and so forth, and hearing time is going to be harder and harder to get. So at least using a hearing examiner, as you do in telecom cases, may be a way to shortcut the process. And we really should consider that somehow household goods movers go through this elaborate process. They have a hearing, but we don't do that for taxis. We don't do it for limousines. We don't do it for non-emergency medical vans. We have a lot of attention paid to people who are moving furniture, but we certificate somebody who takes a carload of kids to the prom without even looking at it. So if the hearing process is that important for household goods movers, why isn't it important for a limousine? And if we start with that premise, we then, I think, can liberate ourselves to think about how to streamline this process. Again, I'm not advocating no review, but I am saying a more efficient and less costly review would be a benefit to the public and a benefit to these people that are just trying to get permission to earn a living. We are currently, the current practice, if somebody wants to use an electronic bill of lading, is to require a waiver. Seems to me the regulation on its face does not prohibit an electronic bill of lading. I don't think it explicitly says anything about paper. And so I would just like the commission to adopt a practice that an electronic bill of lading is okay. That's a minor point, I suppose, because the bill of lading is typically approved at the hearing, but it just seems like one more thing we don't really need to be doing. Number 7, I had recommended the use of the commission accepting the commonly used accord forms, and RMS will be happy to know I'm withdrawing that recommendation. I didn't understand the implications of it for the transportation department, and I certainly don't want to burden them. Number 8 is my 8th recommendation is that we allow movers to give binding estimates. And this is a proposal that was made in docket 2020-204T, Rudy Rue's moving crew, where my client simply said he just wanted to be able to tell people what a move was going to cost and charge them what he told them it was going to cost. And that proposal seemed to have some appeal to the commission during the hearing, but in the commission's ruling, they said that they felt like it was something that really needed to be handled through regulation. Well, here we are. Georgia allows binding estimates. North Carolina allows binding estimates. Both of these states have maximum rate tariffs, and I'm not going to steal Mr. Propasky's thunder on that, but the basic premise in both of these states is you can tell people what they're going to have to pay. Now, if I hire somebody to remodel a bathroom, for instance, they typically come in and they say it's going to cost $5,000. And I say, great. Don't worry about how much time they've spent remodeling the bathroom. I take 2 or 3 bids, and the one that looks most reasonable and has the right materials and the right people, I'll take. And I don't expect them to come back to me and say, well, you know, it took 2 days more than I thought it was going to take, so here's a bill for $8,000. And honestly, when people come to hire me to do household goods movers cases, I don't tell them, I can't tell them, I'd never be hired if I told them, you know what, I bill at $300 an hour, and I'll bill you what it costs. Good news is, if I come in low, you'll only have to pay for 4 hours of my work. But if I come in high, we don't want to discriminate against the other guy who hired me, so you're going to have to pay $7,000. It is what it is. That's what we do with household goods movers. I don't think that's a consumer protection. I just don't. I mean, we worry that, they're going to do it too quickly, that somehow they're going to give somebody too good of a deal. Honestly, if you preserve the right of the consumer to say, I'll pay you what it is, but allow the mover to give a binding estimate, what's going to happen is that consumers are going to do what consumers do. They're going to shop. They're going to go from one place to the other. Why not put that in the regulation? We proposed a binding estimate terms for a binding estimate that ORS agreed to in the Rudy Ruse docket, I think you just adopt that into a regulation. It were largely taken from North Carolina. The other aspect that we need to consider with the binding estimate is the complaints that you get. We don't regulate estimates now. So if a mover, and movers give estimates all the time. The one time that we've really been dealing with complaints that I can recall in the past 10 years involved just that, an estimate. I suspect that's what happens with ORS, where the mover gives an estimate, and naturally he's got an incentive to estimate competitively, right? So he says it's $5,000 to make the move, and then he gives them a bill at the end of the move for $6,500, and they say, "Hey, what's up? You estimated at $5,000." Well, it took a few hours more. The consumer gets mad, goes to ORS, and what's the outcome of that? ORS looks at it and says, "No, that's exactly what you should have charged. It took him that many more hours and that much more time." I think you eliminate that source of consternation with the moving industry if you allow movers to extend binding estimates. My ninth recommendation really does not involve movers directly, although there's a part of it that I'm right now that I want to talk about. But that involves liability limits for passenger carriers. We're requiring the minimum limits. And this came up a few years ago, and I remember there was a lot of protest against it when the commission considered it, but I think the commission needs to revisit this. Again, let's take the example of the limousine carrying a carload of kids to the prom. It gets in a wreck. 25,000? That enough? I don't think so. As far as I can tell, we don't even require underinsured coverage. So somebody hits them, they've gotten the minimum. You got 10 kids knocked up in a wreck and no insurance. Somebody's going to turn around after it's a miracle it hadn't happened yet. But somebody's going to come around if this scenario unfolds and says, who allowed those limos to go driving around with minimum insurance coverage? And the answer is going to be Public Service Commission. I really think y'all need to take a look at that. Now, on the flip side of this, the commission has been in hearings informally asking movers to carry $25,000 in cargo coverage, whereas the minimum, I believe, is $2,500, right? And I understand the sentiment. It's valid. I mean, $2,500 isn't going to cover much when it comes to breakage. But what I'm not sure we're considering are two things. One is the standard limitation on liability for a household goods mover is 60 cents a pound. That's common across the country. Now, if you divide, I did the math on this, I don't have it handy, but if you divide 25,000 by 60 cents, I mean, it's like 40,000 pounds. That's the size of a medium shipping container on a cargo liner. It's cargo insurance is wildly expensive. I mean, typically we're seeing people pay more for cargo insurance sometimes than we do for liability insurance. And raising the limit, when you have a liability limit of 60 cents a pound, is really just making people pay premiums for coverage that's never going to be used. Most cargo insurance, most cargo carriers, most household goods carriers offer, and certainly any person moving furniture, any shipper can buy third-party insurance on the market. So I just wanted to point out that I'm not sure we're getting what we want when we raise the cargo limits or ask people to agree to raise the cargo, to buy 10 times the minimum coverage on cargo. Commissioner Williams, I know, asked for driving records and background checks from applicants. And again, I certainly understand the sentiment. And as you know, Ms. Boyd, my clients who have had criminal records have voluntarily disclosed them every time they've come to the commission. I just felt like it was the right thing to do if they were going to evaluate the applicant's character, and the commission's always been very gracious in the way they've evaluated things. But if what we're getting at with driving records and criminal records is we're afraid these people are handling people's goods, we're really not addressing the fact that the applicant's not necessarily the only person or even the person who's going to drive the truck. He's going to have a dozen of employees. Sometimes they'll be transient. There may be temporary labor, and we're not getting background checks on any of these people. Now we can do a background check. We can get a driving record. I mean, that's really not a huge deal for one applicant, but I'm not sure what we're driving at. No pun intended. I also, if we're going to do that, I would like to know, and I think the commission would benefit from telling the public what the threshold of disqualification is. Because if you don't, you run into a trap of saying, well, this person has a criminal record. He has a marijuana conviction, but it's 4 years old. He's okay. This guy, he's got, he had a shoplifting conviction. It's 6 years old. We're not going to take him. I think there's a trap there. Right now, there's no regulatory basis for disqualification. But if there is a regulatory basis for disqualification, it needs to be, according to EEOC guidelines, reasonably related to the job. And it needs to have a rational justification, and it needs to be clearly demarcated so that it doesn't result, even involuntarily, in a discriminatory effect. So that's my word of caution about requiring driving records and criminal background checks. In addition to, are we talking about a sled check, which is $25, or are we talking about a nationwide criminal background check, which might be $150? Again, if these things are going to be required, they need to be clearly defined, and their purpose, I think, needs to be clearly explained. So thank you for the opportunity to present these remarks. I hope they're accepted in the spirit in which they're intended, and I look forward to hearing from everybody else.
Thank you, Mr. Duraney. The remarks are being taken in the spirit in which you presented them. I appreciate them. Staff appreciate your comments. I just had a couple of questions, please, sir. So,
Yes,
for the notarized signatures, I'm not sure. I think at one point, I don't know. I don't know if that was because at one point the applications for Class C carriers were adopted as the prospective carriers' testimony. I don't think that's the case, though, because we don't require an affidavit or notarized signature on regular testimony and other dockets. So I'm not sure. I'm not sure.
I think it's just one of those things, I mean, this has always been the redheaded stepchild of the commission, and it's just an artifact of history.
Right. Okay.
I mean, if you were the back of a bill of lading, my God, it's like 17th century English. I mean,
we will look into that a little more. The time frame for adopting the form orders, And you
Yes, ma'am.
mentioned the family court order. So basically, I'm familiar with what used to be form orders for family court. I think we had, when I used them, we still included findings of fact. The conclusions of law, I think, of course, were already there, but I think we still had to write the findings of fact on that form order.
Okay.
And you're thinking you would be okay with that, because that might.
I am okay with anything that results in my client being able to get his certificate after the vote. I typically submit an order before the commission votes. I almost always do that. But right now, first of all, they're in such detail that, again, we're adding cost to the process. And secondly, the commission's review and revision of them takes 4 to 6 weeks. And if there's just got to be a way that that's not necessary.
Yeah, I understand what you're saying. That was my only question as to how. I'm not saying it can't be accomplished. I was thinking about the time it might take to craft some the findings of fact, which I think perhaps would still need to be included, but because of the statute. But just wanted to point that out. I understand your point, though. I understand your point. And then I heard you the eliminate published notices for Class E, and I think you were using probably as your legal authority 5823-590. I don't see in their statute either where, unlike 5823-300, which specifically states that an affidavit of the publisher of the newspaper for Class A, B, or D certificates must be provided.
Right.
I don't see the same language in 5823-590. So I've marked that statute. I understand your argument about the shipper witness, the hearing examiners. I just wanted to talk to you about that really quickly.
Sure.
So I think perhaps one of the reasons the commission has not scheduled the transportation cases before hearing examiners just yet, or special agent or examiners, I can't find in chapter 23 of the code where statutes exist in the electrical utility section under 5827-2030-2030, and the telephone statute 58.9.10.20 for the special agent or examiner. And I think maybe that's one of the reasons these transportation cases have not been heard before a hearing examiner. You
I
have
have
any
not
thoughts?
thought of
Okay.
that. No, I really, that had not occurred to me.
Okay. But once you review that, if you want to provide more thoughts, I think staff would love to hear them. But just wanted you to.
Sure.
All right. And then, okay, the electronic means, you withdrew number 7, the binding estimate. I'm curious, do you know why it's called binding estimate instead of a binding quote?
Just what we came up with. I mean, that's my verbiage and Rudy Rue's verbiage.
Yeah.
I mean, it was an estimate. I mean, it could be a quote, whatever.
Yeah, I was just thinking if the commission adopts the binding estimate, it's really, if it's binding.
A
You know,
quote.
yeah.
I think
So
that
that's
may be a better word. Yeah.
okay. Does the ORS's proposed language for 103-198 help at all? Let me find it again, Mr. Attorney. I just want to make sure.
103-198.
Yes. They have at the bottom of the first section fixed rates, and then the next page says variable rates. Oh, it says maximum, minimum, or other alternative. Would you think maybe that's where, if that language were included regarding the binding estimate, binding quote, it would be under number 2. Maybe we could other alternatives such as binding estimate or binding quote.
Yeah, I mean, I'd like to Yeah, I'd like to see it.
Okay,
You know, you specifically mentioned, so to remove any doubt about it, yeah. Fixed rates that are not subject to change without commission approval. The one thing I'd say about variable rates that incorporate a minimum, so I'm not sure if a fixed rate just means a tariff, if they're just talking about a tariff there, or I guess we'll let ORS speak to
yeah,
that. I would like to see the quote, you know, explicitly included. I would say that I've seen in Georgia, when I was looking into the different rate structures, they've gotten themselves in a little bit of a pickle where the commission's like setting a maximum mileage rate and a maximum fuel rate. And so the price of gas goes up and everybody's got to come. They've got an association that does it, I think. They need to come back in and say it's time to let us charge more for per mile because the cost of gas has gone up. I don't think, I think you want to avoid getting yourself into a situation where you're setting rates. I don't think it's necessary and it's going to be problematic.
okay. And that's all I have.
Thank you.
Thank you, Mr. Turini. Okay, next, Ms. Pittman with the Office of Regulatory Staff. Are you ready to present your comments?
Good morning, Ms. Floyd. Yes,
Good morning.
thank you.
How are you?
First off, I would like to thank Mr. Turini for withdrawing his recommendation to use the Accord form. Our staff here really appreciates that. And for our edits, most of what we submitted really just intended to kind of clean up and streamline the regulations, added some definitions that weren't originally included that needed to be in there, that sort of thing. And our intent was to provide clarity and promote uniformity within the regulations. So those are the edits we feel that we've made, we feel accomplished our intentions there. And the edits were made, some were made to align with industry standard and current commission practice. Some things were just a little outdated. And instead of going through line by line, since we do have quite a few red lines, I'm happy to answer any questions that you have.
I apologize, Ms. Pittman. I was running, trying to do more than one thing at one time. Okay, I'll look through my notes. Thank you. So, if we can start, I don't have many questions, Ms. Pittman, but under 103-102, the Class C Charter Certificate number 6, where the words "and which remuneration is determined on an hourly basis." Would you mind letting me know why that should be deleted?
Some trips are done on or charged on a per trip basis and not just per hour. So taking out that language would include however the fees are handled, whether it's hourly or per trip.
Thank you. Okay, moving on to 103-133. 1B, where the sentence, additionally, the applicant can file a statement indicating the applicant's purpose for seeking a Class E certificate, the applicant's 5-year plan, if the commission grants the applicant a Class E certificate, and such other information that may be contained in a business proposal. And so I would like to ask the same question, why that should be deleted?
It's permissive. It's not a requirement. So we thought, strike it since it's not a requirement. And I think it usually comes up, I guess, in a commissioner question. I know Mr. Turini has his asked that question of his applicant when they're on the stand. But that's why we struck that.
Okay.
Recommended that.
And before I move to my other questions, with the exception of number 7, which of Mr. Terrani's comments, which he's withdrawn, is ORS in agreement with Mr. Terrani's other comments?
I don't believe we oppose what he recommended. Some of the items I think we'll need to look more into, like the insurance, changing the insurance limits. I think that
Okay.
might need to involve the Department of Insurance, other stakeholders, but we don't have any, we're not in opposition of anything besides the Accord form.
Okay, I'm sorry if you said that already, but I am curious. All right, moving on. Is the rationale the same for the next under 103 passengers, 133, section 4, little a, fit? Well, the applicant must demonstrate or the commission determines the applicant's safety rating is satisfactory. This can be obtained from USDOT and SCDPS safety records.
Let's see. I believe the Department of Public Safety doesn't issue safety ratings for those types of carriers. And so that is not something that we require for the, we don't require for Class C certificates, and they're also not, they're only required for the Class C charter bus, excuse me, not Class C
Passengers?
cabs.
Okay, so SCDPS does not issue safety ratings?
Correct.
Thank you. Okay, the reduction of hours for under section 6A1 little f, driver must complete instead of 12 hours, 6 hours of in-service training related to passenger and vehicle safety. Just wanted your thoughts there.
I don't think we just rephrased it. Currently, it's 12 hours and it includes the, I'm trying to find the page in front of me, includes the like CPR training. And we just kind of broke it out to make sure there's 6 dedicated hours to driver training.
Okay, so that's probably in another section. Let me see. The CPR does not include CPR first aid training. I think that's in another. Yeah. Okay, that's under A1A, right? The driver must possess at least the medical examiner certificate, an American Red Cross standard first aid and CPR certificate.
Give me just 1 second.
Okay.
Yes, that's correct.
Okay, so the total training is still 12. It's just 6 here for in-service training, and then the other is under A1A, the other 6.
Correct.
Thank you.
Ms. Boyd, may I interrupt?
Yes, sir.
Do these, the regulation we're talking about here, the 6A1, A through K, who does this apply to? Is it just all passenger vehicles?
No, this part I think just applies to non-emergency. I said passengers. I apologize, Mr. Durrani and Ms. Pittman. I was actually 6. I see 5 there is charter bus certificate, and then 6 is for non-emergency. So no, sir.
Thank you.
The section we're talking about now is just non-emergency. Thank you. Okay. Now, I saw there are a couple of sections, I think, Ms. Pittman, where reference to the CFR and Title 49 Parts 37 and 38 were struck. Have those been deleted, or are they no longer applicable? For example, under
covered when we say meet state and federal requirements. We didn't cite to the Americans with Disabilities Act.
Okay. Just made it broader. I understand what you mean. Just in case the law changes or the sections change.
Yes.
All right.
Yes, correct.
Gotcha. All right, this one was interesting for me. Over on, where are we? There's 7. I think it's 7 PC and N Class C taxi and Class C charter carriers. So it's number 7. And we're still under, I think, 103.133. All right. And then the engaging in business section for Class C taxi and Class C charter. So that's to be 7A6. And it's the language there, engaging in business, and the regulation is, there's a proposal to delete it.
Yes.
Would you tell me why, please?
So we don't, that's not our process anymore. We don't do the individual revocations. I don't think we've done it in 10 years. We rescind orders of applicants who do not come into compliance within 90 days of the PSC issue order date, and we do it by submitting a bi-monthly rescinded report to the PSC. And then the PSC administratively closes the dockets of those applications.
Thank you. I'm moving on to regulation 103.150. Well, I apologize. I think I'm. Yeah, 151. Excuse me, Ms. Pittman, 151. And number 3, where you've struck, provided, however, a tractor permit card may not be transferred to a truck. Is that just no longer applicable?
Correct.
Okay. All right. Oh, and the statute regarding selling certificates, 103.155. Do you see where that's been struck?
Yes, we struck that because the transfers of a certificate is covered in 103.135.
Okay. Thank you. I already asked you about your position on the bills of lading, I think. Your position, you think right now. So I won't ask you that. And under 103.193, hearing and publication on new rate schedule. 103-193, section 2. Other approved methods, I think perhaps you mean on the company's website, or?
Yes, I think we need to look into this a little bit more to see what options are out there. We just don't think people are reading the newspaper, so
Okay.
we don't think people are getting notice.
Okay. Ms. Pittman, that's all I have.
Great, thank you so much.
Thank you. We're going to move on now to Mr. Popowski.
Thank you, Ms. Boyd. I appreciate it very much. While we have Ms. Pittman on, can I ask one question about 103-173, striking the valuation language? And if I could get their thinking on that.
You mean the new language that's been added?
Yeah.
Okay.
Yeah. On one, well, let me see what she's added. On one, yeah, that new language.
So currently, there's no minimum for valuation in the regulations. I think it's just been past practice to do the 60 cents per pound, which is from federal regulations. So we just kind of put language in there to kind of set that.
A Class C carrier chooses to offer evaluation options higher than the STB's required minimums. Guests must be provided with terms and conditions and pricing prior to the service being rendered. That's standard. Yeah, I see that. Okay. Okay.
And if you have any
All right.
additional questions, we're happy to talk with you and walk through any of this offline.
Yeah, I would like to just. Okay, I'd like to maybe run that by one or two clients, that section, just to make sure we're okay. And I'll get back with you on that within a week. Would that be okay?
That sounds great. We look forward to hearing from you.
Okay. Okay, if I can respond generally, first, I want to thank the commission for taking the time and the initiative to have this workshop and have this review of its regulations. It's always good to do a tune-up. And it's the first time it's occurred, by the way, to the credit of you, Ms. Boyd, and your staff in my career. So kudos for that. Secondly, the same to Mr. Torini, who for providing an outline of what I think are pretty much the relevant issues that I would have in mind to be considered by the commission. Now, let me just first state as background. On an interstate federal level, all that is required for a household goods carrier is to file an application form, essentially file an application form, file evidence of insurance, and then it is on its way. That is the entry requirement for a household goods carrier to move goods between states. So there's no hearing at all on the federal level on this. There's a short period where it's published in the Federal Register, and there too, there's sort of an archaic requirement. If anybody wants to intervene, they may intervene, and nobody does. So to get on the road between states, it's a less costly and more simple method than we have here in South Carolina. Now, other states and their intrastate regulation, probably 5, 6 or so years ago, a client had me survey, not in depth, but what other states are doing in this arena. And we're one of the 2 or 3 states, I think, and I'll leave this maybe perhaps to the commission to maybe survey, that go through the process of a hearing to enter the household goods business. It is similar in those other states that are, quote, where entry into the business is deregulated. It's similar to the federal level. I might also add, for non-household goods carriers to enter their businesses in South Carolina, similarly, the South Carolina Department of Motor Vehicles Motor Carrier Section has a process known as the Certificate of Compliance, where there too, you fill out a simple 2-page form. If you're a limited liability company or a corporation, you attach the documents and a certificate of good standing from the Secretary of State indicating that's who you are. You file the forms E for liability and form H with that section, the motor carrier section, and you're on your way. So you could carry anything else in South Carolina other than household goods. You can carry steel, you can carry widgets, you can carry anything, food products, you name it, that goes on a truck and on a van, on a flatbed, anything, based on that relatively simple process. Now, I'm not beating up on South Carolina for its current system in general. In my view, it has had a very therapeutic effect when clients come to me and they have to apply for authority, that they know that we take their conduct seriously in this arena. I too share Mr. Torini's admiration for the moving industry, and people who are untrustworthy can easily get into it. And the problem becomes that they can load a whole truckload of people's lifelong belongings into their truck. And they either en masse don't show up, or things are stolen, etc. So this industry deals with some important possessions for people. And reliability and honesty and trustworthiness is important. And I think this commission, through the process of its application process, and I'll get more to the hearing process, has helped keep people on their toes, very much so, to the point where in my career that I have yet to have a case, maybe one I know of, what I would call an enforcement case of misbehavior by a household goods mover, either one I had previously represented or otherwise. So the process sort of in general has stood South Carolina in good stead, in my opinion. I do believe, though, let me just tick off the things I do quickly that I agree with in Mr. Torini's presentation. And I won't elaborate any more than what he said. I agree with the notices about publication, about banning the newspaper notices. They are expensive. They are not effective, and I don't see any reason to do so. On the federal level, you don't do it, and I endorse that proposal by Mr. Torini. On the shipper witness situation, I agree wholeheartedly with that. Again, that is an exercise that only costs the client money, has not had any effect on who is granted authority or not. And I think I agree with that completely as well. I agree with him on the binding estimate. I think that the tariff provides the hourly rate and other charges that a carrier will charge. And if a carrier based on those rates wants to, for instance, say, I can do this in 10 hours, and I will promise you that I'll do it in 10 hours at that rate that's in my tariff, then they ought to be allowed to do that and be held to that, even though if it takes them 15, 16, 17 hours. That's their problem. If a mover wants to make a business decision to give a binding estimate based on their tariff, I'm completely in favor of that. So those are the items that I absolutely agree with in terms of Mr. Torini's presentation. Let me go back and go through the ones I have some comment about. I also, by the way, let me add to my agreement on electronic bills of lading. I agree wholeheartedly that that is the era we're living in, undeniably today, and indeed, on behalf of a client, all my sons, I asked for commission approval and received it for them to implement electronic bills of lading. And indeed, as I predicted to my client, I've noticed on the commission's daily docket, there have been 3 or 4 other movers that have similarly applied for that approval. 100%, this is the world we live in. This is the way they should be allowed to do it. Going back now first on the application and the 2 pages, there are 2 pages that require a notary. One is the agreement to be served electronically, and the other is the safety certificate. And frankly, I have to disagree with my brother and respected practitioner, Mr. Torini, on that I don't see that that is a big problem to get a client to notarize those 2 pages, get them back to me, and I include it in the application that is filed electronically. Okay, so the client can send it to me, I can download it, I can add it to the application and file the application electronically. That in the old days, they had to come to my office, bring it to me, etc. So I really don't have heartburn about that. On the orders, the commission has a good history of getting out orders roughly, I would say, within 2 weeks of a directive being issued, which has been satisfactory. I've had no client complaints about that. Recently, there was one order that lasted, if it gets beyond 2 weeks, then clients get a little itchy because Mr. Torini is right. They're waiting to begin business and charge those rates. Now, on the other hand, they chose when to file an application to the commission. They decided when they want to do it. An interesting point is that there's peak period and there's non-peak period in the household goods moving business. The peak period are generally when kids are out of school, obviously, so that runs from Memorial Day to Labor Day, is when that's when movers really make their business. That's their Christmas, so to speak. And they certainly, if they want a rate increase, they have to contemplate getting that in place prior to peak period beginning. And I think that behooves them to think about that. Of course, and if they do that, I don't think they should have to wait a month between a directive and an order to get an order from the commission. So I just would encourage the commission staff to try to maybe informally have sort of a 2-week rule if it can. I understand the commission's docket is very full on the utility side, and that the household goods regulation is really the lesser of the industries that the commission has to worry about on a day-to-day basis. So I want to acknowledge that point too, but just encourage the commission, if possible, to have an order out at least within 2 weeks. And it's, behooves us as practitioners and the lawyers for the applicants. I submit form orders and I try to get it in within no more than a week of a directive, because it depends on what else. That could be in a hearing, depositions. I have my own schedule as well. And if that helps the commission do it, I try to get that within a week and hopefully try to get something back out from the commission, a final order within a week and a week thereafter. I would like to commend the commission on the quality of the orders that have come out. Most recently, I had on an amended tariff for 4 of the All My Sons locations, and they were very, very good orders, as has always been the case with the commission, I felt. So I felt that the commission has done a very professional job in the language and in the terms of their order. So kudos for that as well. Number 5 on hearings. Let me say this about that. One thing that has been good about COVID is what we're doing right now, that people we can do these virtual hearings. I recently had one in Annie. I've had 2 hearings during COVID, most recently involving a passenger service, Antioch. And I think I can't remember who my client was, but I had one on the Class E application. Both have gone very, very well. I didn't have to leave Charleston. The clients didn't have to leave their places of business. The commission was online. I presented the evidence. The commission staff worked with me with its usual efficiency in preparing in terms of exhibits ahead of time. ORS, of course, worked with me in their typical professional and collegial way. And we were able to have a nice hearing in both cases. And so my suggestion to the commission, I have no objection to hearing examiners utilizing that if so is the preference for the commission based on its other work and the other demands that are placed on the commissioners themselves. But I would encourage the commission to have WebEx hearings post-COVID, because I think they've worked very nicely. That's one thing we have learned. And it doesn't hurt for my client, either before hearing an examiner or a commissioner or the commission in full, to see the commissioners. I keep thinking about the movie where Robert De Niro starred, Meet the Fockers. And I used to do this with my children with, I'm watching you kind of thing. If you remember those scenes in that movie where he was talking to his future son-in-law. And similarly, the commission has that kind of effect on people entering the business, that the commissioner's around. Okay, that once you get your license, you're not leaving the eyesight of the commission. And also, it's very good for the commissioners to see who are going in this business. Fortunately, most of these people, as Charlie's clients have been, are very worthy future business people in South Carolina. They're hardworking. It's I wouldn't go in the household goods business. I'm thrilled to represent them. I love them, but the business is it's like you really have to develop a taste for this business, because it's the only part of trucking where the trucker packs and loads like it does. In all the other elements, you pull up to the back of a warehouse and a forklift wheels the goods into your truck, and you make sure that it looks good, and then you close the back of the truck and you're on your way. You don't come to a person's home, an individual's home, and help pack their goods or receive their goods and then load it onto the truck itself. And so these people are angels, in my opinion. And I think they like, not that they like, but they like seeing the commission, who's going to be a part of their life, and the commissioners like seeing them and hearing their stories. Many of them have military backgrounds. Many of them have worked for another carrier for 10, 15, 20 years and has decided to start their own business and take that risk. So frankly, I've enjoyed them. But I think the logistics of having to travel back and forth to Columbia, which they have done, if necessary, they have done that. But to pay me to involve, they don't pay me for all my time on the road. That's another story. But to hire a lawyer to get ready for that is more expensive than hiring a lawyer to get ready for a WebEx hearing. So I strongly encourage the commission, both in this arena as any others, to continue doing WebEx type hearings, be they even hearings in chief or even motions. I think the only thing I have left is this criminal background check and driving record, thought by or suggestion by Commissioner Williams. I am not enamored of it for this reason. I'm certainly very much enamored of people having good driving records and not having criminal records. However, those issues belong to other agencies. The driving record and the regulation of driving belongs to the Department of Motor Vehicles. The criminal, whether or not you have a criminal record, belongs to our law enforcement agencies, our solicitor offices, our courts. They handle that. The federal government, the Federal Motor Carrier Safety Administration, on its application to be a mover interstate, does not have any such question on their application and makes no such inquiry. And so I think you're getting into that arena. First, it's not, other agencies are dealing with those issues. And secondly, for the commission itself to be dealing with those issues and saying this guy's record is not so bad and that woman's record is bad, or they're drawing lines, I think you'll find yourself that you're getting into a very slippery slope there and opening up, frankly, a can of worms that the commission itself is not equipped to judge. Courts are equipped to judge whether one should be convicted or sentenced for a crime. And the Department of Motor Vehicles they're equipped to determine who can safely or not drive on our highways. And so I would strongly urge the commission not to get involved in those issues. Let me just, I will comment on get a comment to the RS on the valuation question. And just for the record, on the federal level, once one gets a certificate to operate as a household goods carrier, there are consumer-like regulations, primarily that a consumer gets what's called their rights and responsibilities, a booklet showing what the carrier has to provide to them in terms of inventory, a bill of lading, etc. And then secondly, more importantly, there's a right to arbitration if there's any kind of cargo dispute, et cetera. There are processes for whether or not you have a right to arbitration. There are some regulations that the feds have that I will call consumer-like regulations. I haven't reviewed them carefully lately. I don't see them much in my law practice in terms of clients hiring me to defend them against those regulations or a claim against those regulations. But the commission may want to just review that themselves or conduct another workshop or conduct another rulemaking that looks into whether or not it should adopt none or part or all of any federal consumer-like regulations. It has nothing, they are not unique to whether the shipment is interstate or intrastate. There are related to the relationship between the carrier and the customer and the household goods mover. And so that might be something for another day under a separate rulemaking to take a look at. So that is all I have to say. And thank you very much for the opportunity to do so.
Thank you, Mr. Popowski. Thank you for that last issue that you brought to my attention about the federal regulations and consumer protections, or the relationship or rights that customers have related to the carriers that they hire. So we'll look into that. I don't have any questions for you, Mr. Popowski. Thank you.
Ms. Ford, may I add something to what Mr. Bukowski just mentioned?
Yes, sir.
In the federal scheme, until very recently, there was an opportunity for state commissions to enter into agreements with the Federal Motor Carrier Safety Administration to enforce the federal consumer protections on for interstate carriers. So in other words, you could bring a consumer could bring a complaint to the Public Service Commission if it was entered into such an agreement about a mover that took it from Columbia to Raleigh, for instance. That regulation has been recently suspended because I think the Motor Carrier Safety Administration is revisiting the way those agreements are done. But it is something the commission may want to keep an eye on, because it would be a way for you to actually extend protections for consumers. We have Fort Jackson here, and I mean, there are a lot of people moving in and out across state lines, and you could become an arbitration forum for resolving these disputes.
Mr. Torini, do you have any idea where that reg might be in the, I guess, the CFR?
Well, yeah, I can share it with you. It's as I said, it's if you go to it now, it just says reserved for future use.
Oh, okay, okay.
And because they're redoing the reg.
Okay.
So it was I can find the citation at some point, but I imagine within a year or so. You may just want to look at that rulemaking process.
Okay. Thank you. And Mr. Parker with the South Carolina Department of Consumer Affairs.
Yes, ma'am. Thank you. The Department of Consumer Affairs is the state's consumer protection agency, and we offer some comments under our authority as the state consumer protection agency. We interpret and enforce the state's consumer protection code. It involves a lot of aspects of consumer credit, which includes matters of interest rates. And so in our review of the motor carrier regulations, a couple of the regulations caught our eye. In 103-199.5, there's two subsections there regarding overcharges and the repayment of overcharges.
Okay. Mr. Parker, would you hold on one?
Mr.
Parker, I apologize. Yeah, I apologize. Mr. Popowski, would you mind if you have not muted your speaker? Would you please?
Oh, I'm sorry again. I'm bad.
That's okay.
Yeah, I will.
All right, thank you. Please proceed, Mr. Parker.
Okay. So the first item has to do with willful overcharges. These comments are similar to those that we've offered in the telephone utility matter. I should say that also, having to do with willful overcharges. The regulation references an interest that would be refunded. In addition to the amount of the refund, there would be interest as prescribed by the commission. However, our search of the commission's materials, we could not find any prescription of the interest rate. So we questioned whether the commission could clarify what interest rate applies to a willful overcharge by motor carriers. One statute that we did cite in our public comment letter has to do with a different type of utility, but is analogous nonetheless because it talks about an interest rate that is owed for an unapproved portion of a rate. So that's why we included the section having to do with electric and gas utilities there. Basically, the commission could clarify what interest rate applies to a willful overcharge situation. And then secondly, the inadvertently overcharged type of situation where the motor carrier is required to refund. We think based off of our experience generally with mediating consumer complaints, where a refund is at issue, that there could be, or the commission could provide an additional reasonable consumer protection by requiring those refunds to be given within a specified time frame, and require interest to be paid on that overcharge if the refund is not issued within within that specified time frame. So those are that concludes our comments. Those are the only two regulations that we mentioned in our comment letter.
Thank you, Mr. Parker. I only wanted to ask one question. Would you recommend the statute that you provided for me in the telecommunications regulation regarding the legal rate of interest? Would you recommend that the language in that statute be, yes, sir, considered for those regulations that mention interest, the two that you just referenced?
Yes, ma'am. So that is, again, that is Title 34, Chapter 31, Section 20. So that's 34, 31, 20.
Right.
And that sets the legal rate of interest at 8.75%. That's what we talked about in the telephone utilities workshop. So that could also be considered by the commission.
Okay. That's all I have. Thank you.
Thank you.
Okay, everyone. Does anyone have any other points they'd like to make regarding the transportation regulations?
Not I.
Thank you, Mr. Popowski. Okay, well, on behalf of the Public Service Commission, thank you for attending our last notice workshop at this point. We want to thank Mr. Turaney, the Office of Regulatory Staff, and Ms. Pittman, Mr. Popowski, and finally, Mr. Parker with the South Carolina Department of Consumer Affairs. I informed the participants at the last workshop that the commission staff's next steps include drafting a package that includes our proposed changes to all of the regulations beginning from 103-100 through 103-800. And we will issue those, publish them on DMS, and electronically serve you with our proposed changes. We won't start the official drafting process until probably spring, May, June next year. But we want to provide everyone an additional opportunity to provide any additional comments prior to starting that official formal process. So other than that, I hope that you have a great weekend and we will see you next time. Thank you.